Hello friends, in this video I'm going to talk to you about the important medical regulatory laws across the world and also that in India, and we will have a small comparison. So three important laws are the ones that I am going to talk. One is HIPAA, that is Healthcare Insurance Portability and Accountability Act, that's in USA. GDPR, General Data Protection Regulation 2017, that's of European Union. And also in the Indian context, we have the DPDP Act, Data Privacy Digital Protection Act 2023. So we'll start with HIPAA. So the thing is, in HIPAA, initially it was designed for the people who jump from one companies to another. They need their insurance policies to be portable, right? So that was the original purpose. But later, as time progresses, it got introduced into the data protection, especially in the healthcare. So what HIPAA does is, it has something called as protected health information. In the electronic sense, you have the electronic protected health information. And what it says is that the people who access it, it should be authorized. And when you store it in the server, it should be encrypted, and it should be encrypted in transit also. So that is what the importance of HIPAA is. It's not only non-electronic ones, but electronic protected health information should also be safeguarded for the privacy of that particular patient. And HIPAA, if you see, as time progresses, further acts got introduced. Right? There was an act in 2019 and 2009, that's the High-Tech Act. And in 2013, there was something called as the Omnibus Rule also. These were the further addendums to HIPAA, which further enlarged its scope. See, for example, like if there is a breach of data privacy of more than 500 people, the whistleblowers can direct it to the Health and Human Services, HSS, and also the Attorney General of that particular state. So HIPAA makes sure that the data for a particular person, without his or her consent, it shouldn't be used for any other business purposes or any other purposes which is not directly communicated to the patient. So for example, so that is with the HIPAA. Now you come to the GDPR. GDPR is not only confined to the healthcare, but it is in general for any companies. Like for example, in the case of HIPAA also, it's not only restricted to US. If any company which wants to do work with the USA related firm must also comply to HIPAA. Similarly, that's the case with the European Union also. So if any of the companies, or just say the business associates, wants to do business with the European Union, they also have to comply to the 7 GDPR principles. It has the accountability, like data minimization. It has transparency, which all points to this thing that without duly consulting or without the due consent of the particular individual, their data should not be misused. And even when you have like collecting data, you shouldn't have some automatic checkboxes like that. Everything that the customer himself or herself has to take and checkbox, so that there is no hidden agenda behind it. So that is the purpose of HIPAA. And if asked, the company, the business associate or the data fiduciary, they have to provide a proper report of the data, and the data owner, that means the data owner in the sense that the concerned person, his or her data, they can edit it, and if necessary, they can ask to erase it. So now when I have just pointed out these things, just say that what happens if a data breach has happened. So the thing is that in the case of HIPAA, there can be hefty fines as high as 1.5 million US dollars. And if you look into the GDPR, it is as high as 20 million, right? It has high as 20 million, or even 4% of the annual revenue of the company, whichever that's the higher. Now comparing both of these, let's come to the Indian context. Now we have the, I've told you initially, there is the Digital Protection and Data Privacy Act 2023 by Ministry of Law and Justice. Even before that, we do have certain regulations. For example, we do have quite a few regulations by CEDESCO for the drug trials. And at the same time, for data privacy, we earlier had acts. For example, the IT Act of 2000 with its sections of 42A and 72A. In 72A, we have fines even up to 25 crores, right? And then we have the Clinical Establishments and Regulations Act 2010, which actually made sure that even when some clinical trials are done in hospitals, they have to follow certain guidelines and taking the patient consent. So the essence is effectively the same as HIPAA and GDPR, but if you look into the DPDP Act, it is more in tune with the GDPR. Because what happens here is, for example, you are in a hospital and if you feel that your data is not used for the right purpose, you can directly complain to the hospital authorities, and if the hospital authorities will have a vendor, a software vendor who will be doing these things, it can come to them, and if your problem is rectified, it occurs at the, then and there. I mean, that's the end of the story. Otherwise, how it happens is like there is a data protection board, DPDP board, which acts like a quasi-judicial body. Quasi-judicial body means something in the lines of National Green Tribunal, where a certain people section are there which are the subject matter expert, and the other half are the judicial experts. So they can produce an award, and even if breaches like this have found out, it can even range up to even 250 crores that can effectively wipe out the company. So this is the way, in a way, that India, the data privacy and data protection are taken adequate care of. Right. So these are the three important acts. So when it comes to HIPAA, then GDPR, and in the Indian case like this. So it's not really there. If you look into several countries, just say Canada or even Australia, they also do have their privacy acts associated with it. So when you do business with these countries, especially related with healthcare, you have to understand certain principles. Is that it's not the problem with collecting data. What they are focused is on who is accessing this data. Is it the authorized person who is accessing the data? Even if authorized person can use the private data for some purpose, it should be with the patient consent. And some cases in which if certain decision can be taken by the doctor, or in certain cases where in case of patient's life is in danger, in certain of these anomalous conditions, other than that, it is the consent of that particular patient that matters. And data privacy breaches have happened. Like in 2018, Facebook had been fined. And also there was a situation that too in 2018-19 when the Marriott Hotel, around 300 odd credit card details of the customers were somehow got breached. So these are all data privacy breaches that has resulted in substantial fines and resulting in the blacklisting of certain companies. So when doing business in these countries, even as a whole in the world, the people and the governments are more getting concerned about the data privacy. So this is one thing I wish to point out in this video. In doing business for a healthcare related domain, data privacy is of utmost importance. Thank you.